This is Barry Zalma speaking for Claim School Incorporated, Zalma on Insurance, with a case that is really not related to insurance except for the fact that the defendant was probably defended by an insurance company. This case deals with charitable immunity, where a rape by a priest was decided to not be part of a charitable function, allowing for immunity to be applied against a plaintiff suing the priest. The plaintiff sued the Roman Catholic Bishop of Springfield, a corporation sole, and church officials for the sexual abuse by church leadership that he allegedly endured as a child in the 1960s, and for the church's handling of his complaint beginning in 2014. In John Doe versus the Roman Catholic Bishop of Springfield and others, a July 28, 2022 decision of the Supreme Judicial Court of Massachusetts, the defendants moved to dismiss the complaint on the grounds of common law charitable immunity and the doctrine of church autonomy, the latter of which is derived largely from the religion clauses of the First Amendment to the United States Constitution. The Superior Court judge denied the motion. The primary issue presented to the appellate court was whether the defendants may use the doctrine of present execution to appeal immediately from the denial of their motion to dismiss, even though final judgment has not yet been issued. The doctrine of present execution permits an appeal before final judgment when the appellate issue concerns a matter that is collateral to the underlying litigation and that cannot be addressed fully after final judgment. The Massachusetts court concluded that common law charitable immunity, as it existed before the legislature abolished it in 1971, would be lost if a charity protected by the immunities nevertheless had to litigate. Now, in the 1960s, when the plaintiff was approximately 9 to 11 years old, he served as an altar boy at a parish in Massachusetts. He was abused sexually by multiple church officials, including a priest at the parish, the pastor of the parish, and then the Roman Catholic Bishop of Springfield, Christopher J. Weldon. The abuse included severe anal penetration and occurred in a rectory bedroom at the parish, a camp in a different town, and a building adjacent to the parish. Weldon allegedly dragged the plaintiff into the room where at least one other altar boy and 2 priests were present and commanded one of the altar boys or priests to get the plaintiff on the bed. The altar boys and priests grabbed the plaintiff, flipped him onto his stomach, and pinned him to the bed while Weldon and others brutally raped him. After an investigation by the church, the Roman Catholic Bishop of Springfield at the time, defendant Michael T. Rozanski, wrote to the plaintiff in June of 2020 stating that he accepted the former judge's conclusion and asking the plaintiff to accept his apology for the terrible abuse the plaintiff had to endure as a young child and the chronic mishandling of the plaintiff's report by the diocese time and again since 2014. Unable to accept the apology, the plaintiff sued the Roman Catholic Bishop of Springfield and several church officials who had helped investigate the plaintiff's allegations. The defendants moved to dismiss counts 1 through 7 for failure to state a claim on which relief can be granted on the ground of common law charitable immunity. They moved to dismiss counts 8 through 14 on the ground that resolving them would require the court to become entangled in a religious organization's review process, namely that of the Diocesan Review Board, in violation of the religion clauses of the First Amendment. The doctrine of present execution allows an appeal from otherwise non-final orders that are 1, collateral to the rest of the controversy, and 2, interfere with rights in a way that cannot be remedied on appeal from a final judgment because, for example, protection from the burden of litigation and trial is precisely the right to which a party asserts an entitlement. An erroneous denial of immunity from suit cannot, by definition, be remedied after the party asserting the immunity already has litigated the matter to final judgment. And immunity from suit always is considered collateral to the underlying litigation. Distinguishing between immunity from liability and immunity from suit, the court must look to the purpose behind the immunity rather than the words used to describe it. Now, the First Amendment prohibits civil courts from intervening in disputes concerning religious doctrine, discipline, faith, or internal organization. It permits hierarchical religious organizations to establish their own rules and regulations for internal discipline and government, and to create tribunals for adjudicating disputes over these matters. The rule's central purpose is to address the historic philosophical concern with government interference in religious affairs by maintaining the constitutional separation between religion and government, at least originally, after purpose was to prevent civil courts from addressing matters in which they had no competence. If the appellate court was to extend the doctrine of present execution to all important issues that theoretically cannot be remedied after final judgment, then the exception will swallow the rule. The defendants' church autonomy arguments were not before the appellate court properly, and therefore it refused to address their merits. Common law charitable immunity, on the other hand, although it was abolished by the Massachusetts legislature in 1971, still applies to counts 1 through 7 of the plaintiff's suit, because those counts describe conduct that allegedly occurred in the 1960s, and the abolishment of charitable immunity by the legislature was prospective and therefore did not apply. In protecting charities under the common law, Massachusetts courts reasoned that funds held in trust for a charitable purpose should be used only for that purpose. Decisions sustaining the complete immunity view rationalize that the resources of charitable institutions are better used to further the institution's charitable purposes than to pay tort claims lodged by the charity's beneficiaries. Unlike ecclesiastical abstention, then, the purpose of common law charitable immunity was to protect certain parties from the burden of litigation and trial. Therefore, an interlocutory appeal is necessary to protect the rights of charities claiming common law immunity, and the doctrine of present execution applies to the charitable immunity arguments in this case. At common law, charitable immunity extended only to wrongdoing committed in the course of activities carried on to accomplish the charitable activities. The abuse allegedly carried out by Weldon and other church leaders was not, and could not be, related in any way to a charitable mission. There's nothing charitable about rape of a child. Accordingly, the judge properly denied the motion to dismiss on the ground of charitable immunity for the counts alleging sexual abuse of the plaintiff. On the other hand, a negligent supervision claim is exactly the sort of allegation against which common law charitable immunity was meant to protect. Therefore, count 6 for negligent supervision should have been dismissed. Reaching the merits, the appellate court determined that common law charitable immunity insulates the Roman Catholic Bishop of Springfield only from the count alleging negligent hiring and supervision. It does not, will not, and cannot protect the Roman Catholic Bishop of Springfield from the counts alleging sexual assault against the plaintiff, as these allegations do not involve conduct related to a charitable mission. Therefore, the order denying the defendant's motion to dismiss was affirmed as to all counts except count 6, on which judgment will enter for the Roman Catholic Bishop of Springfield. In my opinion, regardless of the egregious abuse perpetrated on the plaintiff, the defendants properly asserted immunity for parts of the suit since they involved the charitable function of the church, while the rape of a young boy by high members of the church had absolutely nothing to do with its charitable function, and provides an example of why the state did away with the immunity. But since it did not do away with the immunity until after the plaintiff was raped and injured, that immunity does not apply in any event, but does apply to the one count. This video was adapted from my blog, Zelma on Insurance, which is available at zelma.com/blog, and to which you should subscribe so that you can see and hear as well as read all of the daily blog posts on insurance matters. The insurance company defending the church in this matter should be commended for having a lawyer who is trying everything in the world to protect his client, and should consider probably entering into a settlement as soon as possible. Thank you for your attention.